I'm not playing games and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea
If
agreement.
If you go to trial, listen to me. If
Yeah,
you go to trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. He's saying assault family violence. The evading arrest is I
Listen.
plead guilty.
It's evading arrest or detention with
But what
the
are you
use.
looking at? I'm saying
I'm
Look,
looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014, you
Right.
were
Hold on,
convicted of
just
something
Mr.
else. Okay.
You've probably already tried. Let me take care of it this way.
I-
Place that in front of your client, please. Now, that is cause number 21-36426. That indictment alleges in paragraph 1 that you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020.
Yeah.
How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not? You plead guilty or not guilty?
So if I'm telling you no content, what is that?
It's nothing and it's nothing. You're not allowed. I can take a plea of no contest or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty,
I'm saying
period. I'm about to set your case for
that's
trial.
saying that I'm not. That's basically saying that I'm.
We're not going to argue the law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I
Doesn't-
state that.
I'm not going to
Go
argue
ahead.
the law
Fine,
with
no
you.
guilty. Just sign. Go ahead.
I don't-
That's guilty. Go ahead. That's what y'all want anyway. That's
Listen.
fine. I'm cool, ma'am. Just go ahead. and
Well,
get
you're
the
not.
guilty.
You're really not being cool, and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me the guilty.
Nothing here.
Plead guilty. There
Okay.
you go.
So you plead guilty to evading arrest or detention
Yes,
with the
ma'am.
use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence December 5th of 2014. Is that true or not true that you have that conviction
That's
on your
true.
record? Okay.
And that's not the same
That's
case
okay.
as far as
Look-
evading arrest, ma'am. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly. And that's, listen, so Mr. Campbell,
That's
that's,
15.
wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay. So I have well, let's go to the next case then. In cause number, and here's that indictment. In cause number 22-39050, you're charged with the And in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no contest, but guilty now.
So are you pleading guilty to this charge?
Yeah.
Okay. And did anybody force you to plead guilty in cause number 2239050?
We just answered it.
I know, I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
I just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take
No,
account.
I think you did. You did, but let's go. So no.
Okay. So I have in both of those cases here on the tablet, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
I understand what we signed, the documents.
Okay. You have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed. Okay. I'm not trying to, doesn't have to be that difficult. Just get in, get your deal and get out. You're making this way more difficult than it has to be. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest could result in your deportation? If you're not a U.S. citizen, could result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
So what this is, I'm
I'm required to ask everyone that. Are you a U.S. citizen?
yeah.
Okay. State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're not.
You said
I just printed the wrong thing.
She asked me if I thought that there's evidence you weren't. I said, no, there's not. He's competent.
I just printed the wrong stuff. Did I print both of the
Give him the
certifications?
thing on that.
Sure.
Please. Please.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, foul, please. I ain't drinking,
Mr. Campbell, you ready?
Yeah.
In cause number 2136426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
So can you say that on record?
I'm on the
Yes.
record.
No, I'm saying say that how long I've been in custody.
I don't know.
I've been
I don't
in
have that
custody going on
information.
5 years.
Okay, you'll get all the credit that you are entitled to get by law. And cause number 2239050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 2239051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time served?
Go back with the bailiff.
Is you gonna bring me my papers for my time
They
served?
have the jail.
Mr. Clark page, it only shows that burglary is pending at the moment, and it wasn't set for trial. It was just essentially a new case that he was not able to appear for because he's here. His offer's 25 years on this case. I would imagine. If it's a burglary pending in Harris County, it's gonna be lesser.
We'll take care of it first.
Yeah, and I think, Judge, honestly, in not being on a trial docket over there would make it a little bit easier for me to give this attorney over there and get something worked out that will take care of both sides of it.
Okay.
I mean, of course, still has to deal with the ICE issue.
Okay. So I'll just do a normal reset that'll give you time to visit with the Harris County Attorney and Mr. Nichols, and then go out and visit with Mr. Lazo. And we'll see if we can get an announcement at the next court date.
Sure, Judge.
Thank you, Your Honor.
Thank you, Ms. Bursch. Denzel Spikes, Mr. Lewis.
Judge, hold on, I know Mr. Hopper was looking at that one.
Okay, I'll hold it. Robert Eaglin,
Yes,
it's a
Judge.
bond hearing. Robert Eaglin. All right, sir, you are Robert Eaglin? And give me just a second. Mr. Eaglin is charged with aggravated assault on a family member with a deadly weapon, and Mr. Lewis has filed a motion asking that his bond be reduced. The bond is currently, let's see,
It was 150.
what is it set at now? Do y'all know?
I think 150.
150. And it looks like there was we were set for trial, and there was the state requested a continuance, and so Mr. Lewis has filed this motion to reduce bond. Ms. Malfino, what is the state's position?
Yes, Judge, the state did file a formal written motion to bring it before the court. I certainly understand that Mr. Eaglin via Mr. Lewis certainly entitled to ask for bond reduction based upon that announcement. Where I am is that the complainant in this case, if the court will recall, it was originally handled in CDC. She was unable to be located. So although the often stated in the indictment looks old, he has not been in custody for that length of time. So I'd like you to take that into consideration. She has recently had a stroke. She is still in recovery for that medical condition. I spoke with her on the phone. She's always been very attentive in reaching out to us. It's difficult. Her mobility is severely limited. Her speech is still limited based on that stroke. And for that reason, I would ask the court to consider allowing for a continuance off of that December 8th docket, and so that we could know in advance so she doesn't have to leave her rehab facility. And I've discussed that with Mr. Lewis, who's always been very courteous about it. I understand the necessity for him to ask for a bond.
Sure. Mr. Lewis?
And Judge, that parceless cut, that involves, of course, the length of time that he did sit in custody while he was in this case was pending over in CDC. I think it was a very lengthy time, almost 3 years is what he was in custody for before that case was dismissed, because they could not locate her. Shortly after that, of course, it was refiled. He's been in custody all of this time. We were ready to go to trial because the stroke happened right before the last trial set. And I think, we discussed it at that point, which I was gonna, and this was the first update we've gotten that she's still dealing with the rehab and everything.
Okay. So,
And typically, Judge would know not to ask more than once. It's just a very severe medical condition.
sure,
And it's
yeah,
very
no, I'm
serious
going to grant the
aggravated
motion for continuance, but in turn, I think I'm required under
Yes.
17151 to do something with regard to the bond. So I want to get some specific information from you, Mr. Eaglin, so that I know conditions to place on that bond. Where will you live if you make bond?
My mother,
What is her name?
Marva
Marva
Eaglin,
Eaglin, okay. And what is that address?
3705 East Lucas Drive.
So that's here in Beaumont,
Yes.
okay. As far as you know, Ms. Molfino, obviously there will be some restrictions and no contacts. Was there any issue that you know of when Mr. Eaglin was out from the time that case was dismissed until the case was refiled with any type of contact or threats or communication with the complaining witness?
Not that I'm personally aware of, Judge. I certainly would be happy to talk to Mr. Laird about it. I know that the complainant at the present time is very concerned for her safety, just based upon the aggravated nature of the offense, and I don't feel like it's necessary to show the court the pictures of that, but I think you would probably.
I'm looking at the probable cause, so it's an allegation of being stabbed multiple times?
Her throat was slit, yeah.
Okay.
Again, I certainly understand the bond requirement and would ask that in the event he does postpone, that he have to wear a GPS at all times so that we can monitor his whereabouts. I know the complainant's whereabouts. I would like him not to know that. And also for him to remain in Jefferson County, specifically in Belmont. He also has a prior felony conviction.
I'm sorry?
He also has a prior felony conviction.
Okay. All right, so here's what I'm going to do, based on the, my granting that motion for continuance. I am going to grant the motion under 17.151 to reduce the bond as well in Mr. Eaglin's case. I'm going to reduce your bond to $25,000 in your case. There are going to be several conditions that are extremely important. The first is that you will be required to wear a GPS monitoring device at all times. You will be on house arrest except for employment with my permission. So if you have opportunities to get employment, you need to get with Mr. Lewis. He'll let me know. All it takes is an email and I can approve or not, things like that. Also, obviously you can come to court and you can visit with your attorney, medical doctors, things like that. But other than that, you are to be on house arrest at 3705 East Lucas here in Beaumont. You're not to leave Beaumont. You are going to be restricted to live and work in Beaumont, Texas. Do you understand those restrictions?
I can speak now. I'm trying to change venue, motion to change venue because this case is prejudiced and it's been dismissed and it's been brought up 20 days later while I was out there helping my dying mother. I didn't do it the first time.
Okay, so here's the thing. You got a lawyer, motion to change. All right, you're not
I
getting.
wrote the state bar about it and I'm.
Your motion to change, all right, listen, your motion, listen, don't talk over me, okay? Because I can change my mind real quick on what I just did.
I'm not even trying to bond out, ma'am. I'm trying to get out of the county with this case so that this case can get.
That's denied. Your case is going to be here in this court with me, okay?
Yeah, I understand.
So
But I don't need the bond though.
then I'm going to withdraw everything that I just said. I'm going to deny the motion for bond reduction. And so what we'll do is just reset the case on the next available trial docket and we'll move forward with trial. Go back with the bailiff.
And Judge, that's what I was going to say. I'll give you value.
Okay.
Because at the last time I talked to him, we were fine.
Okay.
Then all of a sudden, he stopped wanting to visit with me.
Okay.
So-
Just send something over and we'll get it taken care of. I know. Okay. If you don't want to do it. I made all kinds of good notes here. Russell Bean, Mr. Lewis.
Yes, Madam Judge. And if we can hold on that, we have
Sure.
an agreement worked out.
Okay,
But he's gonna need to go plea on the misdemeanor cases first.
okay,
I was just waiting for Mr. Cole to get here. He's his attorney.
gotcha. And then Dijon Banks.
Thanks. That one, I've talked to Ms. Malfino about. There's a lot of discovery on that one.
Okay,
And that we still need to.
so you need some more.
Yeah.
We're gonna reset Dijon Banks and hold Russell Bean. It sounds like he might need to, at some point, go downstairs, go down the hall. I mean.
And thanks, Judge, at some point I may ask the court for your assistance in procuring some school records of the young child. In this
Okay.
case, there's some autism involved, and sometimes those are difficult to get out to the court order, but I'll do that.
Okay, yeah, just let me know. I'll sign an order if you need it. Okay. Mr. Burbank, are you ready on Brandon Bell?
Brandon Bell?
I did.
Yeah. Is that okay if I just do it?
Yeah. Mm-hmm.
He's in a wheelchair. Hey,
Good morning.
good morning, you're right. I added 2 counts.
No, I think he's the only one. They're just confused on which one.
All right, I have it ready, so.
Good morning, Frank.
Good morning, sir. You're Brandon Bell?
Yes, ma'am.
And this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true in a motion to revoke deferred probation, pled true to counts 2, 3, 4, 6, 7, 9, and 10. And there was not an agreement on probation for aggravated assault with a deadly weapon. And I've received that updated report. Has everyone had an opportunity to review that report?
Good time, Chad.
I have, Your Honor, in addition to some medical documentation that Mr. Burbank has provided.
Was that provided to me?
Not,
Okay. I'm sorry.
probably not.
Okay. Is it, what should it have, do I,
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
uh-huh. I don't know what you're talking about. Yeah, I mean,
These are medical records from Spindletop.
okay,
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working,
okay,
which I think are factors that need to be addressed.
Probably in addition, Judge, if I may, to the fact that you recall the complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know
Okay.
that's been a concern, but I had some difficulty with that portion of the case.
okay,
And if the court would also remember, she was expecting another child, they are expecting another child. And
okay.
She's
So what,
also-
go ahead and make argument and then I'll,
She's also controlling the checking account. He's getting settlements and he's providing the money to her for the children. They still have a house together. But he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, had some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation. He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, which he does have the funds that he has to be able to give to her. But if there is some program that he can have that's outpatient to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now in November, but the problems have been going on. But he does need to go back to Spindletop. He does need to say this is what you do or not. I mean, according to the pre-sentence report, he is reporting. It's not like he's not reporting. He's trying to pay or has been paying and trying to do stuff. I think he just needs a little bit of a correction and see whether or not they can do it. And couple all that, I've had extensive conversations with his wife. I've tried to tell her the way it has to be as of yesterday. We've talked over the phone in the way that it would have to be in reference to separation until they learned how to possibly get along together. So that's what we're asking for, Your Honor.
Ms. Malvino?
Judge, would the court like to hear evidence with respect to counts 1, 5, and 8? Ms. Lopez?
I mean, I guess it kind of depends on the
Just in the context of what she has to say.
yeah, for sure.
I call Ms. Lopez.
Ms. Lopez, if you'll raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you may proceed.
Ms. Lopez, would you please state your full name for the record?
Rachel Lopez.
And how are you employed?
I am the high medium risk officer at adult probation here in Jefferson County.
And are you the supervising officer for Brandon Julius Bell?
Yes.
And do you see Mr. Bell to your left in the wheelchair? I'm going to record reflect Ms. Lopez is identified as the defendant.
The record will so reflect.
As a condition of his probation that was granted by this court back in April of this year, 2025, was he given certain terms and conditions that all probationers are to follow?
Yes.
And specifically, you've had an opportunity to review the motion to revoke that was filed back in July.
Yes.
In account number 1, it alleges that he failed to immediately report to you his or her contact information in violation of condition 9. Can you explain that to us, please?
There were multiple instances throughout the time that he was reporting where I would attempt to call the number he had provided at a previous office visit and would not be able to reach him. So then I would have to then search through his associates to find someone else who would answer, who would then say, we'll let him know you called. And so it's standard in our court orders that offenders are supposed to keep their contact information updated due to the fact that most of the time I cannot give out certain information to other people due to confidentiality.
So it's obviously very important that you're able to reach him and advise him of the conditions of his probation, et cetera.
Yes, we need updated phone numbers, addresses, things like that, so that we can specifically talk to the defendant.
And he pled true to additional allegations, including providing some dirty UA specimens being out past curfew. Was he ordered by the court to provide all records and documentations as required by you to you as his officer?
Yes.
And did he do that?
Yes, whenever it applied in regards to like spindle top, yes, those type things. I haven't had any kind of paperwork in regards to the settlement that Mr. Burbank has referenced, but I also recognize that that may be a recent thing. And so that may not be applicable yet, but otherwise, yes.
So some things you're able to verify, but yet others you are not, which is why you felt it important to include the motion.
Correct.
And additionally, in allegation number 8, did he admit to you the adulteration of his UA analysis on or about June 30th of 2025?
Yes, when he submitted that urine analysis that date, it was clear in the cup, and I did make a note of that in my chrono. It should be noted that even if someone is extremely hydrated, their urine is not crystal clear. And so when I specifically asked him in the offices at that date, did you do something to make it be negative? He said yes. And so while the drug test reflects negative, he admitted in the office visit that he had taken something, drank something to adulterate his urine.
And in fact, you and I have had a lengthy conversation in the past about his use or suspected use of K2 synthetic marijuana, which lends to possible negative UAs when in fact he would be positive just due to the nature of that synthetic.
Yes, Ms. Strother, our UA tech, has explained to me that K2 is a difficult drug to drug test for because much like the flu, there are multiple strands of K2 drugs out there, and our drug test can only specifically test for one type. And so if he had not used that specific type, it would test negative. And so the incident reports that I received through Beaumont PD indicated that the effects that they were seeing in their reports indicated synthetic marijuana use.
And that information is also reflected in your update to the court, correct?
Correct.
With respect to how his behavior appeared to be altered, involving odd hours, showing up at odd places, attempting to contact the complainant, et cetera, regardless of whether or not they mutually agreed to do so. And I believe your recommendation is very well thought out and very well put in the updated PSI. Do you have anything to add to the report?
I do not at this time.
I have some questions.
I have some questions.
Yes, sir.
Ma'am, did you ever get his records from Defendant?
I believe so, yes.
And was he under medication?
Not during the time of all of this taking place. I know that since he was out on bond, I believe he went to Spindletop as of August 11th, and that was when he began having his medication the way he was supposed to.
In your report, you stated in the first or second paragraph that while the defendant does report as directed, he has made basic efforts towards paying his fees, correct? So he has been reporting to you.
Correct.
And then you also started receiving phone calls from the victim. Did you have any dealings with the victim at all? Were you here the last court hearing?
I was.
She didn't act very rational either, did she?
Not often, no.
And do you realize that they are expecting another child?
Yes.
And how many other children do you remember?
I believe they currently have 3 children together. I believe this is the 4th.
If I told you that there was a settlement to Scott Brown in reference to the motor vehicle accident that took his leg, you wouldn't disagree with that.
He told me that at the jail when I did my PSI update.
And he's getting monthly, settlement checks or quarterly settlement checks, in which the wife does have access to his account.
That I don't have any knowledge of.
You did also receive telephone calls from his mom, correct?
Correct.
And basically, she said that he's talking out of his head, he has mental health issues, right?
She did at one time, yes.
She didn't know, well, has to be between April and now, right?
Yes.
Because it was put on.
Specifically whenever he was out on bond.
Okay. He did appear or direct to be kind of delusional state, correct?
Yes.
Unable to remember reference to taking medications or injecting, so he was on some type of medication, correct?
Correct.
And that one of his problems is that he has to learn how to remain on his medications in order, from Spindletop, in order to, I guess, try to live life normally, correct?
Correct.
Nothing further.
Anything else, Ms. Malfino? I don't know yet what I'm gonna do, but if, is there any reason based on the injury that Mr. Bell could not go to special needs safety? Is that something that would prevent him from going?
I do not believe so.
You don't think so? You don't think so?
I think there are people that have gone to Spindletop that are
Sure.
in wheelchairs and things of that nature.
Yeah.
I said Spindletop, I'm sorry, safety.
Yeah,
So I think he would still be able to go. I think it would be under special needs.
right, that's what I would,
Yeah.
if that were an option, it would be special needs because that would address both of
That
the.
addresses mental health also, Judge.
Yeah, that's what it's for. I mean, and here's the thing. I think a lot of the mental health is because you're using synthetic marijuana. I mean, that's gonna, so. Ms. Malfino, anything else?
Judge, I think you have a lot of information before you had an ending your decision. I do think it important, and I didn't want to hide behind the fact that we have had the issues with the complainant that she did come and testify.
And that's the only thing that's keeping me from doing probably what needs to happen.
But I don't have an interim update with respect to her.
Have you heard anything?
I have not heard anything since all of this happened. The reality is she's called me multiple times and complained and said that Brandon's here and she wants him gone. But Ms. Lopez, please don't send him to jail. She is very back and forth about it. My largest concern, Your Honor, is that the offense that the defendant is on probation for is extreme. And my biggest issue in truth is the fact that Mr. Bell does not take any responsibility for any of it at all.
I don't disagree.
Can I just have one question, Judge? Did this accident happen after
When did your accident happen?
November 4th,
of last year?
was a,
Of last year?
So all this has happened since he's been on
No, but
probation.
Was this
No, prior.
before? Was that prior?
His
to
accident
his
was
accident?
prior to when he was placed on probation.
Right.
No, but how about the incident itself?
Oh, the underlying offense?
Yeah,
April of last year. So the underlying offense was prior
prior to his.
to the injury. But the injury was prior to probation where he's still, I mean, regardless of you can still do things to injure someone, to harass someone, to put someone in fear with or without a leg. And that's what he's done. That's what you've done. Still make babies with her. I mean, I don't know. I mean, that she was pregnant. The whole point of this is you beat the crap out of her when she was pregnant, and now
Third child,
we've got the fourth.
correct.
Judge, would you like me to do a notice call for her and see if for some reason she showed up today and
Sure.
court needs to speak with her? Adriana Bell?
Can we do a call for,
Adriana Bell?
I don't know if that's gonna help either, though. We've done that before.
And I don't know if this is a situation where it's the court needs to protect somebody from himself.
Do you want to reset it so I can possibly?
I don't think it's gonna matter. I mean, she's been here before. I've ordered,
No response,
I think I have her mother's here.
but there was a no contact, and now we have another baby. So obviously there was contact.
Can I address that? From what I found out, Judge,
I don't need Snickers from the
Okay.
gallery.
I'm not calling them as witnesses. Every time they got mad at each other is when she got on the phone.
But she got on the phone, but that's him blaming. He beat her. You admitted to beating her. So she's probably scared when he gets mad. And then it gets okay, and then it gets mad. And he doesn't know how to get mad without beating the crap out of her.
I didn't get that indication, Judge. She's been to my office every other day. She's called. I mean, it's really,
I'm not in disagreement that Ms. Bell is also the problem, but my biggest concern here is their children.
separation.
Yeah,
I don't care if they stay together or not, admittedly, frankly.
Yeah.
I'm more concerned about the children involved in this case because of the violence that they're being subjected to. Whether or not the two of these adults can reconcile is between them, but there are children involved that I am extremely concerned about.
I agree. All right, here's what I'm gonna do. Mr. Bell, I don't feel like I have any other choice at this point but to protect your children and to protect your, I don't know if y'all are married, girlfriend, wife, mother of your children from you. I understand the mental health issues. From what I can tell, most of those are self-induced because you were using K2.
It haven't been an incident since I've been on probation.
That's not true.
I haven't had no abuse case since I've been on probation.
Okay, so you haven't abused her, but you weren't even supposed to be around her. I gave you don't talk over me, because y'all I told you when I put you on probation that she cannot give you permission to violate my order.
Yes, ma'am.
She can't say, it's okay, come on over.
She came to my house. I was staying in the house. She wasn't staying there.
Lock the door, kick her out. You're the one that's gonna go to
I know,
prison.
she said that she called the laws to kick me out, and you said it still was an issue. She called the laws to kick me out. My mama came and got me, and I've been staying with my mama. I ain't been around her. She been calling the laws on me every time she come to my house. I paid $100,000 cash.
Why are you still having sex with her and having babies?
That's early on.
Early on when? We've only been doing this for 6 months. You've had 6 months and all this has happened in 6 months on probation.
It happened 3 months because she finna have a baby next week. 3 months before I was on probation.
So what if she shows up at your mom's house?
She's not gonna show up over there. She know her and my mama don't get along.
Probably for good reason.
I would represent to the court that there is a problem there, Judge, because even when we talked about possibly with him seeing the kids without her at mom's, and that wasn't a possibility. It's something between her and the mom, his mom. And I know his mom, his brother has gotten in trouble. She has a very stable job at a bank. She's very straight-laced. His brother was the one in the West End that was burglarizing cars, and the owner stopped him and shot him about 8 times on the road and left him there. But she is very straight-laced, and she just couldn't get off of work this morning because of the bank.
So,
But he needs something, Judge. I mean,
well, but we tried to give it to him.
well, I'm talking about.
I have money now to pay for my battery class too. I have money to pay for my battery class and pay off my probation.
I'm not as worried about you paying off things as I am you having continued contact with her.
I'm not gonna be in contact with her anymore.
Is there a way, Judge, to put him on a GPS and reset this for 60 days?
No, I'm going to make my decision today because I'm absolutely, if I leave him on probation, he's going to safety, period. So we're not going to get out and see how we do and take that chance without having some kind of treatment up front. I don't know. Y'all hold on a second. Just don't take them far. For some reason, Anna, when I pull up the version that should have my notes on it, it doesn't have anything on it. So I don't know if I didn't save it. I have the prior version and the the new version. I printed out that new version and it doesn't have it. The date and all that. So I might need to go back and handwrite something from that date, but just remind me I put a sticky on this. Okay, let's see. Ms. Holmes on Samuel Harmon?
Yes, sir. Samuel Harmon.
So, side note on him, his dad called me and said he filed a grievance on me, but I'm still gonna represent him. But he apologized for filing it because he said he didn't know I was coming to visit him that day, yeah.
Okay, I'll follow.
The joys of what you do.
Yeah.
Good morning. Are you Samuel Harmon?
Yes, ma'am.
And this is 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And Ms. Holmes, what is the announcement?
Yes, Your Honor, if we could get one more reset. We did receive another offer from the state today that I would like Mr. Harmon to review with his family. And also I'll come out to visit with him as well so we can make a decision by the
All
next
right.
court.
I'll reset one more time. Any issues?
Just, Your Honor, that was a 12-year offer that's going to remain open until the next court setting.
Okay.
Withdrawn.
Okay, so Mr. Harmon, it sounds like there's an offer that's on the table that they've going to keep open until that next court date. Make sure you visit with Ms. Holmes about it, visit with your family about it. Sounds like there's not any more negotiation. The offer is what it is. If you want to take it, we'll take care of that when you come back. If you don't, you want to trial, we'll get your case set for trial. Okay, you can go back with the bailiff.
Thank you, Your Honor.
Brittany Litchfield,
Yes.
would y'all, I'll print the first one if you'll print the second one, please. Is Burbank still in here?
Yes.
Mr. Burbank, do you have somewhere else to be?
No.
Okay, I'm just gonna give me just a minute to
Yeah,
do.
no, I was supposed to be in hard copy.
Okay,
Take all that.
okay, thank you. Good morning, are you Brittany Litchfield? Give me just a second to get this printed out. And will your client waive the formal reading of the motion in each case?
Yes, Your Honor.
Ms. Litchfield, in cause number 21-37098, I have a motion to revoke your community supervision. Shows that you were placed on probation December 12th of 2022 for the state jail felony offense of abandoning a child, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Judge, we'll still open, August 6 and 7 on each motion and just proceed on 1 through 5.
In each motion, 1 through 5?
Yes, ma'am.
It's okay. All right, and then in cause number 21-37099, I also have a motion to revoke your community supervision. Shows you were again placed on probation December 12th of 2022 for the offense of abandoning a child, and that was also a 2-year term in state jail prison that was probated for 5 years. Is that also correct? Each of these cases, the state has elected to proceed on counts 1 through 5 in the motions. They each allege in count 1 that you violated your probation by failing to report to the probation department as directed October 15th, October 31st, and November 14th of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 in each case alleges that you failed to immediately report to the probation officer your current address. Is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service hours that were required. Is that true or not true? And then count 5 alleges that you failed to provide verification of entering and successfully completing the parenting class. And is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts in each case because they're actually true? In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Litchfield is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 21-37098, revoke your probation and reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25-37099, also find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with that agreement to a term of 12 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am, and thank you for being here.
On bail, there is one in there
There
that
is.
says revised, yes. You must have not saved it, or.
I must have
It
not.
didn't save it, and then I must have printed and
Got
gave
it.
it to you.
Okay.
So there is, do you need it?
I can, yeah. Yes. Maya Sparks, Ms. Holmes.
I'm not gonna say yes to the yeah, just for the mental stuff, I don't know. Okay. Sorry.
Do you think we'll get a date before Christmas?
Probably not. But now I get to speak.
Good morning. Are you Maya Sparks? And will your client waive the formal reading of the indictment in each case?
Yes, sir.
Ms. Sparks, in cause number 25, DCCR 0145, you're charged with the third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Speak up, please. And then in cause number 25 DCCR 0146, you're also charged with a third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases is for a 6-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Sparks is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later date for sentencing. Mr. Nichols, what is the state's position on bond?
Judge, I'm a little concerned about a PSI bond because of the way these cases occurred. There might be an issue that I do anticipate she at the very least being placed on mental health caseload. I don't think it's a competency issue. I've discussed it with Ms. Holmes, but I don't know if the court's going to decide that either an ISF or safety program is in the best interest here.
Okay.
The facts in this case involve threatening staff at a school, so it gives me a little bit extra concern. And there was one jail incident in the last week that gave me a little concern as well.
Okay.
Yes, Your Honor. So Ms. Sparks and I've spoken with her mother. Her mother is here. On this particular incident, there was a episode. She had a mental episode where she was not on medication at that time. She is compliant on medication now.
Okay.
And we are asking, her mother is taking care of her child. Her child was attending that school that she went to. And so I do feel that if she stays on her medication and stays compliant, that she would be okay. And so we were asking if the court would consider a PSI bond.
I guess the concern is without the probation order where, has she been to Spinal Tap before have you gone through Spinal Tap before? You are a Spinal Tap patient?
She's diagnosed bipolar and major depressive disorder.
Okay. So what I'm going to do, Ms. Sparks, just kind of based on also time of the year, I'm going to reduce the bond, but I'm going to have some very specific conditions on that bond. And you're going to have to follow those conditions Exactly. If you don't, because you're going to have to give Ms. Holmes proof that you're doing some things that I'm going to order you to do. And if you're not doing those things, then I'll issue a warrant for your arrest. We'll get you back in custody until that pre-sentence report's done, and then we know what everything is that you could potentially need. Was there also any type of, or is there any kind of drug issue, or is it primarily mental
It was
health?
just mental.
Okay, so Ms. Sparks, I'm going to reduce your bond in each of your cases to $2,500. If you make those bonds, the conditions of the bonds are that you immediately have an appointment, make an appointment with Spindletop, that you give proof of when that appointment is to Ms. Holmes. So I'm saying the day you get out, you make the phone call, you set an appointment, and Ms. Holmes needs to know when that appointment is. You don't wait a week to set the appointment or 2 weeks or anything like that. You set it the day you get out of jail if you make the bonds. Does that make sense? In addition, I am ordering that you remain on your medication. So now it's not just whether you want to or you feel like you need to, it's a court order. And if you don't do it, you're back in custody. Do you understand? So is her mother okay with her living with her? Where's mom? Thank you, ma'am. And thank you for being here. So I'm going to order that you remain living at your mother's house. You can't go spend the night anywhere else. You can't go anywhere else. You stay there. You go to Spindletop. You get yourself back on track so you can be fine and do this probation and not have any issues. Does that make sense? You are not to go to any of the schools wherever your child or children are going to school. You are not allowed to go there, period. Do you understand? Okay. That's not until I order otherwise. So for now, you cannot go to any school that they are attending. Okay? If somebody needs to pick up and drop off, that's going to be her or someone else. If there's a school program between now and when you come back, I don't care. You don't get to go. Do you understand how serious I am about that? Okay. Any other conditions that you feel
I
like?
think that will cover it, Your Honor.
Okay. All right. We'll see you back at sentencing. You can go back with the bailiff. Okay, I'm writing it all on my docket,
Here, I was gonna say,
so I'll write it again.
you don't have to.
Here, just keep it to the side and I'll do it. Remind me. But I did write it all down.
Okay, thanks.
I redid the paperwork on mine, Judge.
Okay, thank you. Mr. Kimler, what is the announcement on Jeremiah Branch?
I don't know what you use once, but
Okay, I'll hold it and take care of those when they're ready. Mr. Lewis, I was holding Russell Bean.
Just that one, I've gone next door to check, see what Mr. Cole got.
Oh, okay.
But he hasn't, he hasn't.
We're
got it
waiting
yet.
on that. I need to make that note. Okay. What about Denzel Spikes?
yeah, that was completed.
Okay, I'll take care of that when it comes through. Let's see, on Cecilia Delaney, did y'all get her? Let's take care of Miss Delaney, Mr. Parker.
Forgot about that one.
And this is one where they say outpatient, but I don't have,
Do we think she needs to go for longer than the 120 days?
well, it'll be a civil commitment today for a year. So that's why we had to bring her back, because that was just for the 120. And so now I can do the civil commitment for the 1 year. And even though it's recommending outpatient, I'll make it inpatient so that, because we don't have an outpatient.
All the way down number 78 on the list to get done.
For you?
I don't know. I'll go for a while. Yeah, why not? Is it a state jail felony or is it a third? We also need to watch out for
statute.
Okay. Yeah.
Because it doesn't look as if it's a public danger.
Right.
Thought we just did something September.
This one we were trying to get over.
Yeah. Oh, that's right.
No, why they have this journal? That's too big.
Sharon would have done it first try.
All right, this is cause number 24, DCCR 1386, and are you Cecilia Delaney? And Ms. Delaney is in court, was previously found not competent to stand trial, was transferred to the John Dunn Behavioral Science Center for competency restoration for a period of not to exceed 120 days. I have received the report from them, and we'll take judicial notice of the court's file, including that report. Included in that is the trial competency evaluation report, which was prepared by Dr. Mary Ann Robinson. The opinion in that report is that Ms. Delaney is still not competent to stand trial, and that further treatment would be required for competency restoration. In addition, there is a forensic psychiatry report that was prepared and by a Dr. Selleck, S-E-L-E-K. Again, the finding with him is that she is not competent to stand trial. Additionally, we have a physician certificate of medical examination for mental illness from Dr. Selleck. The finding in that is that Ms. Delaney does not meet the criteria for inpatient commitment, but meets all of the criteria for an outpatient commitment, with the specific findings that the nature of the mental illness is severe and persistent. As a result of it, if not treated, that she would experience deterioration and the ability to function independently. And in addition, we have a second physician certificate of medical examination for mental illness from a Dr. Lee. The finding is the same in that Ms. Delaney meets the requirement for outpatient commitment based on the nature of her mental illness being severe and persistent, and that if not treated, will experience deterioration and the ability to function independently. That's it. It's another one. Okay, so that being said, well, is there any other evidence with regard to competency?
No, Your Honor.
So obviously, you guys both know we do not have an outpatient treatment facility in Jefferson County.
Right.
We don't have a jail competency restoration or outpatient competency restoration. So that being said, I have no choice at this point but to find that Ms. Delaney is still not competent to stand trial, and find that commitment inpatient would be required because we do not have outpatient commitment facility, because the nature of her mental illness is severe and persistent, and that if not treated, she would not be able to function independently and live safely in the community without the court-ordered treatment services. And so I am going to order a subcommitment for a period of not to exceed 1 year for competency restoration at the appropriate facility. If there is restoration prior to that, they'll let us know and we'll get Ms. Delaney back. Otherwise, we will wait for their report and have a hearing at that time. Ms. Delaney can go back. Ms. Perazzo, are you ready on Trevon Alexander? Good morning, sir. Are you Trevon Alexander? And Mr. Alexander, I'm sorry? Good morning. And so Mr. Alexander is charged in cause number 25 DCCR 0831 with murder. And Ms. Perazzo, what is the announcement?
Your Honor, if we could have just one more short reset so Mr. Smith and I can try to work out an agreement. We have received an offer.
You've received all the discovery?
Yes, ma'am. There are no discovery issues.
Okay, so what I'll do is this will be the final reset. I'll give you some time to do that. Mr. Alexander, at the next court date, if you guys have reached an agreement, we'll take care of it on that date. If not, we'll get your case set for trial. All right, you can go back with the bailiff. Well, that's great, except that he just got it all done.
Okay, I'm just.
Okay, I'll get to it in just a second. It's not even here yet.
Okay.
Mr. Burbank, on Destiny Williams,
Yes, Your Honor. She's in the back.
and Mr. Kimler, I'll get to it as soon as I can.
Want to take it?
Nope. I don't have it anyway, but.
I don't have the paperwork. Never mind. We're pleading.
For what?
We're pleading to counts 1 and 3.
Okay.
You want paperwork?
I don't know. Do I want paperwork? Is it for what's it for?
Update.
Yeah. Yeah.
Just,
Yeah. I threw you off on the other one. He's gonna have to do paperwork with her.
you didn't throw me off.
I mean, I know it's a new thing, this whole paperwork silliness when we have to do something, but you're getting old. Okay, let's see. So how many are we doing on Branch?
See, he's waiting.
Jeremiah Branch? 8-2 and 8-5. Handle.
Oh, just give up the judge. I emailed you last time.
Good morning. Are you Jeremiah Branch? Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Mr. Branch, in cause number 25 DCCR 1382, you're charged with the second-degree felony offense of assault on a peace officer from September 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? And then in cause number 25, DCCR 1385, you're charged with the second-degree felony offense of robbery from September 17th of 2025. And how do you plead to that charge? Are you also pleading guilty freely and voluntarily? And because you did what they've charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreements in each of your cases are for 10-year deferred probations, $500 fine in each case. You would be required to follow all of the rules and conditions of probation. And there would be dismissals in cause numbers 25 DCCR 1383 and 1384. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Branch is not competent?
Your Honor, I believe he meets the legal standards for non-competency.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back later for sentencing. Mr. Smith, what is your position with regard to bond reduction based on the nature of these plea agreements? I just printed out a PC.
No.
Let me take a look at this one. Good grief. Okay, so Mr. Branch, is there any criminal history? How old are you?
It has
92.
There is criminal history?
One state jail judge.
I think I'm not going to adjust the bonds due to the nature of the offense. I have taken a look at the probable cause affidavit. I just want to make sure that there's a substance abuse assessment done, make sure there's no issues with that and or any mental health issues that would need to be addressed. If we can also take a look at any mental health issues so that I know at sentencing if there's any other requirements that I would want to impose before release so that we don't end up with this kind of issue again. You can go back with the bailiff. Denzel Spikes, Mr. Lewis. And no paperwork on this?
Yes, shoot paperwork.
All right, just have a seat, and I don't have it yet. Let's see, we took care of Lazo, right? Okay, give me a minute for... Mr. Rojas, you have a Byron DeQueer. 2 cases.
Yeah.
This is from the 8th of March.
I'll print the first, if you can print the second, please. Just a second. Good morning, are you Byron DeQueer? Will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Give me just a second.
We can narrow down some of the counts.
I cannot hear you.
We can narrow down some of the counts on the NJLP.
Okay,
There's like 13 counts.
what do you want to go forward on?
We'll go for first 7.
Okay, state's going to proceed on 1 through 7 in each case. Okay. And Mr. DeQueer, in cause number 23, DCCR 1448, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 2nd of 2024 for the 2nd-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct? Yeah, it's just correct that you were placed on probation on that day, right? Are they printing? Huh? I feel like yours is closer, but it takes longer to print than mine. Do we need a new print? What do we need to do? Everything? We need a new TV. We need a new printer. We need new computers.
Thank goodness it's Christmas.
We need new tablets.
Just ask Santa.
Unfortunately, Santa is on the 4th floor of the old courthouse, and I missed that opportunity during budget season to ask for all this extra stuff. Okay. Okay, now, in cause number 23, DCCR 1449, I also have a motion to revoke your unadjudicated probation. This one also shows you were placed on probation July 2nd of 2024 for that same offense, assault on a peace officer, 2nd-degree felony, and that was also a deferred probation for 10 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation, and the state has elected to proceed in counts 1 through 7 in each. Count 1 in each case alleges that you provided a urine sample July 14th of 2025 that tested positive for methamphetamines. And is that true or not true?
True.
Count 2 in each case alleges that you provided a urine sample August 12th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true?
True.
Count 3 in each case alleges that you provided a urine sample August 25th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true?
True.
Count 4 in each case alleges that you tested positive August 26th of 2025 for methamphetamines and amphetamines. Is that true or not true?
True.
Count 5 in each case alleges that you tested positive September 10th of 2025 for amphetamines, methamphetamines, and ecstasy. And is that true or not true?
True.
Count 6 in each case alleges that you tested positive September 16th of 2025 for methamphetamines. Is that true or not true?
True.
And then count 7 in each case alleges that you failed to conduct yourself in a courteous and professional manner at all times when interacting with your probation officer, and that you were argumentative, raised your voice, and became verbally aggressive toward them. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're actually true?
True. Yes, ma'am.
I have here on the tablet some documents in each of your cases that have your signature on them that the state has marked as exhibit number 1. Before you signed those documents, did you go over them with Mr. Rojas?
Yes.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted. Is there any evidence that Mr. DeClaire is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. In cause number 23, DCCR 1448, find sufficient evidence to find you guilty, and at this time, find you guilty. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1449, also find counts 1 through 7 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases, the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Taylon Douglas, Mr. Rojas, the sentencing.
Taylon Douglas.
No, I get it.
He knows to bring him back over here.
All right, you're Taylon Douglas. And Mr. Douglas was previously in court, entered a plea of guilty to the third-degree felony offense of obstruction or retaliation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah,
Any additions or corrections?
no, yeah.
Only that, court is inclined to follow judge and certainly concur with the answer.
In addition, I have received, and you guys should have been given copies of jail incident reports. Have you all reviewed those as well?
We have them.
I'm not, but I take your word for it.
Okay. You don't like to follow rules, do you?
I follow the rules.
You do? You've been following the rules since you've been in jail? Kinda. Okay. So, how have you not followed the rules?
I don't know, just whenever, I say like whenever I get disrespected or something like that.
Oh, so when they disrespect you,
I just,
why do you think you deserve their respect?
cause I don't do nothing to disrespect them.
You don't? You don't? Sitting on the countertops, not getting down, looks like trying to smoke in the bathroom, working out when you're not supposed to be working out, lying about it, saying you're brushing your teeth, teasing and cutting up with and being disrespectful, talking about the officers, act like a little kid. Taking food when you're not supposed to. Calling them some lovely names. B word. Telling them they're white and ugly.
That's what they said, I said?
Mm-hmm.
I don't know, I don't remember.
You don't remember saying that? So here's the thing, how old are you?
19.
19. So you're now on a felony, or about to be, if I follow the agreement, which I don't have to do. You're about to be on a felony probation where you have to follow rules whether you like them or not because you've committed a felony offense. So you don't get to make all the decisions for yourself anymore, right?
Yes.
Other 19-year-olds who don't do this, they get to go to bed when they want, wake up when they want, eat what they want, work out when they want. You don't get to do those things anymore because you committed a felony offense. And if you continue to act like you've been acting and not follow the rules, however insignificant you think those rules are, you're going to end up right back in here and you're going to end up going to prison for up to 10 years. Do you understand?
Yes.
So you have to make some mature decisions as a young person who's probably not ready to make those decisions. It's going to be a conscious effort and a decision on your part to either do it or not do it, right? What's going to happen if I follow this is you're going to go to ISF. ISF is a 90-day program that's intended to help you make better decisions. But let me tell you what can happen. Between now and the time that you go to ISF, you're going to be in jail. If I get an incident report, it's a violation of your probation. You could get revoked off your probation before you ever go to ISF. Do you understand? And it's happened. Ask them out there. I'm tired of you young people acting like you're acting at our jail. They're tired of it. These people are just going to do their jobs, trying to go home, go with their families, make a living, pay their bills, something that you hopefully will want to do at some point in your life. Instead, they got to go to jail and deal with this. The crap from you kids. But now you're an adult for these purposes. If you get to ISF and you don't make it through that program, or I get incident reports from ISF, they send me those, you're not going to get out. You're never going to see the light of day again. You're going to go to prison. It's that serious. Do you understand? Okay. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. Again, if you do everything you're supposed to, this is a great opportunity today. I don't want it to all be negative, because you have some very positive things. You don't have a felony conviction on your record. If you're a convicted felon, it changes your life in so many negative ways. You're not going to get certain jobs. If you want to go to trade schools or school or anything like that, or college, you're not going to be able to do certain things, live certain places, all of that. So you still have that opportunity. And if you get everything together and you follow the rules, at the end of your probation period, the case is dismissed. You will never have a felony conviction. This is the chance of your lifetime to change it and live like the rest of us live, okay? The other side, though, is if you violate any condition of probation, you'll be brought back into court, you'll be found guilty, so you would be a convicted felon, and then the punishment can be anywhere in that range from 2 years up to 10 years in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Again, I know there's other people out there, there's other young people that are acting up. It's going to be up to you to say, I'm not doing it. I don't want to go to prison. All right? All right, you can go back with the bailiff. Yes, ma'am. Hold on a second.
Before he goes, Judge, in light of the fact that you are giving him an opportunity after deferred on the felony in reviewing of his incident reports from the PSI themselves and his juvenile history, which is quite extensive.
Yes.
It is my intention to proceed, obviously with a plea bargain offer on those misdemeanors, but I think it would be important, at least with several of them, to have those on his record so that if he is back, we kind of know what we're going to do then.
So you won't be able to go to ISF until you take care of those misdemeanors. They'll bring you over on a jail day to get those taken care of. Ms. Molfino will talk to that prosecutor. If you enter pleas on those, great. If you decide to go to trial, then you'll just have to wait to go to ISF until those take care of with the trial, okay? Also, I do want to make sure a condition of your probation is that you are not allowed to be in the possession of a firearm of any type. That means in a vehicle with anybody with a firearm. That means at a house where there are firearms. You are not allowed to be anywhere where there's firearms. If you're living somewhere where there's firearms, you either cannot live there or they have to have those out of the house or locked where you cannot have access to them. Do you understand? Okay, you go back with the bailiff now. Michael Dyer, Mr. Rojas. Good morning. Are you Michael Dyer?
Good morning.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Dyer, in cause number 25, DCCR 1340, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from September 9th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Dyer is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser included offense of a Class A misdemeanor assault, sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Correctional Facility. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to, what?
I'm sorry. Oh, he changed his mind.
Yeah, when you can.
I'm sorry. There was just some alternative offers and
Okay.
he had
We originally put up
indicated
paperwork,
one and
right.
then
We originally put up paperwork on the felony, but then
Okay.
changed his mind to the misdemeanor.
Okay, so I'm going to hand you the trial court certification, again, that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Yeah, I didn't say it, sorry about that.
And Judge, he had the lowest level of culpability in that case. There was no
Thank you.
individual who's actually doing the wrong.
Thank you. Marco Gomez, Mr. Rojas.
Comment?
I can see that.
Good morning. Are you Marco Gomez?
Yes.
And Mr. Gomez, in cause number 21-36534, you're charged with a second-degree felony offense of sexual assault from March 26 of 2020. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand that?
Yeah.
And do you want to reject that offer and have your case set for trial?
Well, he told me that I have to sign it today because I don't have, I was gonna get another lawyer.
So here's the thing. Today, I just need to know, there's a couple of things. We'll take them in order. First of all, I need to know if you want to enter a plea of guilty and take the 15 years, or if you want to plead not guilty and go to trial. Okay, so I'll do the rejection and we'll get your case set for trial, okay? Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial quicker. Is that okay with you?
Is it the same thing? I still gotta go to trial no matter?
Yeah. I mean, either you plead guilty and take the deal or you go to trial.
I guess I go to trial.
And are you okay if I appoint a new attorney today?
guess I can go with Mr. Rojas.
You want to keep Mr. Rojas? All right, so Mr. Rojas will begin preparation for trial and we'll get it set for trial. You may go back with the bailiff. Sarah Jordan,
I don't know what her judge, she said she's gonna either hire Mr. Kimler or Mr. Smith with one more resetting.
okay, we'll just do a reset on Sarah Jordan's 2 cases then. And Gerodrick Randall, it's the sentencing. I'm about to have to take a break.
We came for a sentencing before, you rejected that because there's some new cases, we have a new plea.
Oh, okay, got it. Okay, so
No, they're not new cases in this court, no, but he picked up some cases.
okay, so we already went through. All right, are you Gerodrick Randall?
Yes, ma'am.
And so did I just reset it or did I?
Hi.
What?
So in August, Your Honor, he pled true, and I think at that time we were looking at ISF as our agreement. When it was reset for an updated report, then we discovered he had
Yeah.
two new misdemeanors that occurred in August. And so I
Right.
filed a first amended motion October 22nd.
Okay,
So
but we need to go through
We
that.
need to please to that, and then we have an agreement that the court's okay with.
Okay. All right. Will you waive the formal reading of the motion?
He will, Your Honor.
Mr. Randall, in clause number 24, DCCR 0543, I have a first amended motion to revoke your unadjudicated probation. And we're going to start kind of all over. I know we've gone through some of this, but we're going to get pleas of true or not true again on all of
And
them.
Your Honor, with your permission, we've agreed to plead to 1, 2, 3, and then the amended counts of 10 and 11, which cover the several new offenses, all
Right.
misdemeanors, but
Thank you. So it shows you were placed on probation October 7th of 2024 for aggravated robbery, and that was a 5-year deferred probation. Is that correct? The state's elected to proceed on counts 1, 2, 3, 10, and 11. Count 1 alleges that you violated your probation by committing the new offense of unlawful carrying a weapon May 3rd of 2025. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of evading arrest or detention May 3rd of 2025. And is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana.
Right out of the gate, the judge sets the tone. This isn't just about accepting a plea, it's about respect for the courtroom. When a defendant keeps interrupting, even a favorable deal can quickly disappear. And with 25 years to life hanging over this case, every word matters.
May 3rd of 2025, and is that true or not true?
True.
Count 10 alleges that you committed the offense of unlawful carrying a weapon July 13th of 2025, and is that true or not true?
True.
And then count 11 alleges that you committed the offense of evading arrest or detention July 13th of 2025, and is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have paperwork now, again, on the case here that has your signature on it that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Randall's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of robbery, aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institution.
Judge, I feel like we may have originally pled him to the lesser.
I think we did lesser
robbery.
included.
Let me double check. And Maybe because he's one of several co-defendants in that case, and I know at least one of them was pled to a lesser.
I have that we did plead him to a lesser included robbery back in August of '24.
That's correct, Judge. I'm looking at the PSI.
Let me double check with the paperwork though. Hold on just a second. Can you pull up the original? Well, never mind. It'll probably be in here. Never mind. Hold on.
It was put down to Judge robbery.
Okay. Does the state want to,
Yes, Your Honor, I'd ask that I be allowed to amend the motion to take out aggravated and reflect the original.
any objection to that?
No objection.
So I'm going to go back and just to make sure the record's clear, what you're on probation for is the lesser included offense of the second degree felony offense of robbery. So it's not aggravated, it's the second degree felony. And I'm going to make that modification amendment here on the motion with, let's see. I can figure out how to get all this done. Okay, so that being said, I'm going to find you guilty based on the pleas of true to counts 1, 2, 3, 10, and 11, find you guilty of the offense of robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
All right, court.